Welcome back. We're going to finish out this chapter and talking about capital punishment. Capital punishment refers to the use of the death penalty to punish wrongdoers for certain crimes. And death penalty opponents, such as legal expert Stephen Bright, wonder whether, quote, there comes a time when society gets beyond some of the more primitive forms of punishment. But death penalty is definitely a very controversial topic. Some of our researchers point out that the United States is the sole Western democracy that continues the practice, putting it among China, Iran, Iraq, and Saudi Arabia on the list of nations that carry out the most executions. So as far as the methods of execution, the chair remained the primary form of, meaning electrocution, remained the primary form until 1977. And this is when Oklahoma became the first state to adopt lethal injection. And for about 3 decades, states used a similar 3-drug process to carry out lethal injections. And the process, which involves a sedative, a paralyzing agent, and a drug that induces heart failure, was designed to be as painless as possible for the condemned convict. The United States Supreme Court, their attitude about the death penalty has really been shaped by 2 decisions that had been made a century ago. And first, in 1890, the court established that as long as they are not carried out in an inhumane or barbarous fashion, executions are not forbidden by the Eighth Amendment. And since that case, the court has never ruled that any method of execution is unconstitutionally cruel and unusual. Weems v. United States in 1910, the court made a ruling that further clarified the meaning of cruel and unusual as prohibited by the Eighth Amendment, though the facts of the case did not involve capital punishment. So in Bays v. Reeves, this was in 2008, the Supreme Court ruled that the mere possibility of pain does not establish the sort of objectively intolerable risk of harm that qualifies as cruel and unusual punishment. Excuse me. That ruling, though, Bays v. Reeves, applied to the 3-drug process described earlier. For a variety of reasons, manufacturers in America and Europe now refuse to sell those drugs to the United States. But lengthy ordeals by condemned convicts in Arizona, Oklahoma, and Ohio bolster claims by medical experts that midazolam, don't know how to pronounce that, cannot be relied upon to mask the pain suffered during lethal injection. In 2015, the Supreme Court approved the use of the drug, once again holding that a method of capital punishment was not cruel and unusual. So in the 1960s, the Supreme Court became increasingly concerned about what it saw as serious flaws in the way the states administered capital punishment. And finally, in 1967, the court put a moratorium on executions until it could be cleaned up, the process that is. And the chance to do this came in Furman v. Georgia, which was in 1972. So let's talk about the bifurcated process. And these are the stages with this death penalty sentencing. So in that Furman decision by a 5-4 margin, the Supreme Court essentially held that the death penalty, as administered by the states, violated the Eighth Amendment. Justice Potter Stewart was particularly eloquent in his concurring opinion, stating that the sentence of death was so arbitrary as to be comparable to being struck by lightning. And although the Furman ruling invalidated the death penalty for more than 600 offenders on death row at the time, it also provided the states with a window to make the process less arbitrary, thereby bringing their death penalty statutes up to constitutional standards. And the result was a two-stage or bifurcated procedure for capital cases. And in the first stage, a jury determines the guilt or innocence of the defendant for a crime that has, by state statute, been determined to be punishable by death. And if the defendant is found guilty, the jury reconvenes in the second stage and considers all aggravating and mitigating factors to decide whether the death sentence is in fact warranted. So today, 31 states and the federal government have capital punishment laws that are based on this bifurcated process. State governments are responsible for almost all executions in this country, and the federal government has carried out only 3 death sentences since 1963, and usually seeks capital punishment only for high-profile defendants, such as Dylann Roof, who was sentenced to die in 2017 for killing 9 African-American parishioners at a church in Charleston, South Carolina in 2015. And I always like to, that case, if you're not familiar with the Dylann Roof case, I left the Charleston County Coroner's Office to move back to Washington in 2015. And I just have often thought about my coworkers who responded to that massive shooting in Charleston, and thankful in a way that I wasn't still there working, because that would have been a very hard case to work. So, sorry, I got a little off there. So we were talking about, I wanted to kind of talk briefly about the jury's role when we're talking about the death penalty. The Supreme Court reaffirmed the important role of the jury in the death penalty in Ring v. Arizona. This is in 2002. And it involved Arizona's bifurcated process. And after the jury determined the defendant's guilt or innocent, it would be dismissed, and the judge alone would decide whether execution was warranted. And the court found that this procedure violated the defendant's Sixth Amendment right to a jury trial, ruling that juries must be involved in both stages of the bifurcated process. Now, several mitigating circumstances will prevent a defendant found guilty of first-degree murder from receiving the death penalty. In 1986, the United States Supreme Court held that the Constitution prohibits the execution of a person who is insane. And 16 years later, in Adkins v. Virginia, 2002, the court similarly ended the death penalty for mentally handicapped defendants. And then in 2005, the court issued its Roper v. Simmons, which effectively ended the execution of those committed crimes as juveniles. So what does the future of the death penalty look like? The number of executions carried out each year in the United States has decreased dramatically since 1999. And in 2016, only 30 people were sentenced to death, a drop of nearly 40% from the previous year's already historically low tally. And this has continued, and over the past several years, at least 7 states have shut down their death chambers, and they're dealing with these issues surrounding the lethal injection drugs. And some other factors in this decline of capital punishment is life without parole alternative, plummeting murder rates, and of course, the high costs of the death penalty. So that's it for this chapter. I would encourage you to, if you have questions about capital punishment and the death penalty and where you stand on that, do some research. My opinion has certainly changed over the course of the last 20 years. I can guarantee that. And so that's always my biggest advice, is just become informed. Have a great day.